Please rise. Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the appellate are near, give your attendance, you shall be heard. Please be seated.
Welcome. We have almost 7 hours of argument time requested, so please ask for the time that you need, not the time that you wish. We are familiar with the briefs and the records, and if we have additional questions, we will keep asking them. Number 1, People versus Stansler is withdrawn. Number 2, Spoto versus Matos is submitted. Number 3, Vickram versus Anup Pama. Are you both on the same side? Do you wish to argue it since no one else is here? Yes. Okay, I'll give you 3 minutes then. Cabral versus Triangle. Do you wish to argue it since no one else is here?
Unless the court has any questions, I'll mark it down.
Okay, submitted. CaRu versus Realty, appellant.
Respondent, 5, please.
5, 2, and 5.
Thank you.
People versus Kuto is submitted. People versus Ruiz, appellant. 4, 2, and 4. Finch Property versus Blumenfeld, appellant. That is submitted. Everybody wants to start the holidays early. Orano versus 5541, appellant. How much time are you requesting? What? 5 minutes. Respondent? 5 and 4. Rhodes Associate versus Company, IS Company, appellant.
8 and 3.
Respondent? 6, 1, and 4. Beretto versus Board of Managers, plaintiff, appellant.
4, 2, please.
Next appellant?
Appellant, I'll also take 4, 2.
4, 2, 4, 2, and 2. People versus Clark, appellant.
Request 5, 3, Your Honor.
Respondent?
Respondent request 5.
4, 1, and 4. Dawson versus New York City Housing Authority, appellant. Nobody's here on that, okay. Submitted. G. Children, appellant. Oh, is the appellant not here? Okay, do you two want to argue?
I'm sorry, if my colleague who represents the other child is not here, I would ask for 10 minutes. But if they're not here, I can just submit my brief or ask questions.
Are you here for ACS?
I'm here for ACS.
Okay, so you're requesting 10 minutes, but the appellant's not even here. Okay. What do you,
If they come, I'm sorry.
if they're not here for the call of the calendar, they're not here. for purposes of argument. Then you'll submit it. And ACS, do you want to argue?
Unless the board has questions, we'll submit also.
Does anybody want to hear any questions for ACS? Okay, then it's submitted. The whole thing is submitted. People versus Para is submitted. State Farm versus Chiropractic is submitted. Bawa versus JJ Operating, submitted. Everybody wants to go for the holidays, okay. People versus Wallace is submitted. And Gaviola versus City of New York is submitted, and Providence Hotel is submitted. So the first case for today is Vickram.
Good afternoon, Your Honor.
Go ahead.
Your Honor, this case comes from an order that was entered in September 2023, whereby the court declined jurisdiction or basically relinquished jurisdiction over the matter of the minor child that had been abducted from New York to India. When the child was abducted from New York to India, there were subsequently over a dozen orders here in New York that stated that this child's habitual residence and home state pursuant to the UCCJEA was New York, and that the
Counsel,
child...
when you say that there was an abduction, was there any order barring the mother from leaving the United States to travel to anywhere?
There was not an order, however, most parental abductions happen when both parties pursuant to the Hague Convention, which is what we follow in the United States, are exercising custody, and one parent unilaterally takes the child to another country without the consent of the other.
My recollection is that the father was in India attending to his father's illness and subsequent death.
Yes, my client's father...
And then the mother followed him
the
with the child.
The mother followed him and then wrongfully retained the child and refused to let him have any access to the child, which would be a wrongful retention.
So your argument is that the child was abducted because the mother remained in India with the child, as opposed to the mother abducted the child by removing the child initially from the United States. Is that correct?
The initial abduction happened without my client's consent or knowledge.
No, that's not my question.
The removing from New York would be pursuant, I believe, to the Hague, a wrongful abduction because she did not have the consent of the father or knowledge.
Who was in India?
Correct. When she came to India, the father was obviously aware she was there with the child and did not...
I'm going to interrupt for a minute because it's clear that New York had jurisdiction. That's been held and that's been decided. The question is, what's the effect of DRL 76A, which says that jurisdiction continues once the court has jurisdiction until a determination is made that neither the child or the child and one parent have a significant connection with the state. And the court below expressly made that determination that the child and one parent no longer have a significant connection. So no matter how it originally occurred, that is the current reality. What was incorrect about that determination?
I don't believe the court was correct about that determination because of the fact that it did not actually, first of all, ever make a finding that New York was an inconvenient forum.
The child hasn't been, forget about it, it's, what connection is there between the child and the mother with this state at this point? Because they haven't lived in this state for so many years. The child doesn't go to school here.
Right.
The child has no history to look at here or no connection with
Right.
New York for
Which
many,
would be
many
the
years.
case of any abduction. That's the nature of abduction. When you abduct a child, you can't go from, now I've abducted a child, wrongful act, and now therefore there's no connection. You have to go from
Justice
the
Kern, if I may, I know the light's off. May I? Thank you. So let's go back because you keep on saying abduction, but I just don't see it because the child has been in India since 2013. The father knew about the whereabouts since then and also litigated in India as well.
The father litigated a jurisdictional issue in India. There's never been a custody finding by the Bombay court because the Bombay court has not held they have jurisdiction over the minor child yet in these years of litigation. The father argued that the Bombay court did not, continues to argue that the Bombay court does not have jurisdiction because of the fact that pursuant to the UCCJEA, this child's both home state and habitual residence was New York, and you can't create jurisdiction by what was an abduction pursuant to the Hague because it was without his knowledge, or even if you would say he had knowledge at some point, it was a wrongful retention. By the way,
Thank you.
I have a question, please. Go ahead. Do we have an order from the Bombay court saying that it has no jurisdiction over this case?
we have no order from the Bombay court saying anything about jurisdiction about
So
the
it's
minor.
pending?
Correct.
Thank you.
Thank you for your time.
CaRu versus Finale Realty.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant in this matter. Usually I say labor law cases are complicated. I don't think this is all that complicated. It's 2 pages of the record, 376 to 377. It's the affidavit of Mr. Ratchet. If you find that it controverts what my client says, I lose. If you find it doesn't, like we say it does, I think I should win. And I just want to go to the affidavit itself. First, it would have been very easy for his boss to say, look, he was doing a one-time job that had nothing to do with any construction. He didn't say that. He was very, very careful in what he said. And I want to read it with you. I'll go through it. If you have any questions, I'll try to answer it. 377, starting at 7, quote, there was no work being performed at the Galaxy store on February 12, 2020. Well, we know from his statement in paragraphs 3 and 4 that the plaintiff was doing work. So what he's talking about work there, I assume, is no construction.
Counsel, don't we have 2 versions of what happened?
I don't believe we have 2 versions at all. He was on a ladder moved, he fell. So
Don't we have the classic argument of routine maintenance versus ongoing work as part of a project, a renovation project?
That would be correct if you disagreed with my assertion that the affidavit of his boss doesn't deal with that issue at all because it's carefully worded to avoid the overall context of the claim. Now, we all know
Also,
that.
does the affidavit address the question as to whether this was preparatory work essential to an enumerated act?
Does the boss's affidavit? It does not. And here's why. If you look at 7, 8, 9, 10, and 11, every single argument that they make is qualified by the term date of the accident, February 12, 2020. So, for example, 8 says, there was no work being performed on the rolling gate and awning in front of the Galaxy store on February 12, 2020. That's absolutely correct, because the plaintiff said that was going to be done subsequently, and we know from the affidavit of the demolition
It
person.
says it was preparing for that.
It's canceled, of course. Next thing. 9, there was no work being performed on the lighting under the awning at the Galaxy store on February 12, 2020.
Mr. Isaacs, we know that all the different component parts of the project were not being done that day.
Correct.
If at all.
Correct.
We know that. So the issue really is, what was he doing there? Was he doing something to put something on or to take something off in terms of the awning or the signage or the canvassing, whatever it is, to enable it? That's an issue of fact.
Let me suggest here, Judge Shulman, let me try to switch you on that. The answer is it is not, because if you read what the boss said, he's qualifying everything as of that date. And when he says there was no work being performed, there wasn't work being performed because the plaintiff said I was doing the work, and there's certainly no way he was doing the work after he fell because you saw those photos. He had an open fracture of his ankle. He wasn't doing anything. So my suggestion isn't that there couldn't have been a question of fact. There clearly could have been a question of fact. It was easy to say. He was fixing a banner. It had nothing to do with any work that was going on. There was no other work going on. He never said it. I'm not saying that it couldn't have been said. I'm saying it wasn't said. And if you read this syntactically, linguistically, and in terms of what was said and what wasn't said, there isn't a word in this affidavit that materially contradicts what my client said about the overall project, and it could have been done, so he didn't do it. So my argument isn't necessarily a labor law argument, it's a very simple for you summary judgment argument. I made a prima facie showing of entitlement to judgment as a matter of law with my client's testimony that this was part of an overall project. We know it was an overall project. We, in fact, know that this was work that was authorized because you heard the boss's statement. He was holding the ladder, and he was there. So it's not an unprotected act. I don't read his affidavit as setting forth anything other than a clever way to avoid the fact that this was, in fact, part of an overall project. And under Pratt's, under Saint and its progeny, that's sufficient to trigger labor law liability.
Do we have any evidence that shows invoices, construction plans, permit applications, and so on to tie everything together?
You do, and it's on the affidavit of Arzu, Arzu Herrera. This is affidavit 418, and you have an invoice, Your Honor, 419. The invoice is dated 12/23/2009. It talks about the gate. Remember, there are two parts to this. One is the facade, the lighting, and the awning, and then there was the rolling gate. So they were doing two parts, two-part job, and that's the page it's on. You actually have the invoice and his affidavit as well. I'm sorry I went over.
No need to be sorry.
Good afternoon. My name is Evie Kazansky. I represent the owner of the property. So I just want to start by saying merely because you fall off a ladder does not mean that it falls under Labor Law 240. The lower court got it right with respect to whether or not this is an enumerated activity.
What about counsel's argument that there's no proof in the record that this was not part of an ongoing project?
So the first issue is this was premature. So if you looked at the whole entirety of the record, the plaintiff makes his motion, then there's affidavits made, then recorded statements made, because the employer was not brought in until July, then this motion is made, then the employer's part of the action. So in the first instance, nobody had spoken to Mr. Rashid before this motion was made. So that in and of itself is premature, and the issues that he's talking about with respect to an affidavit, the affidavit is in opposition. On the date of the accident, if you read the affidavit, there's no projects going on even peripherally. That's the point. The plaintiff for HMY, which is the employer, is basically saying that they went up to fix a loose banner. That in and of itself is already, the fact that you're asking him questions about the affidavit raises issues of fact. The prima facie, basically saying, I fell off a ladder, oh, this whole project, the awning, look at the pictures, there's no lighting under the awning, actually. And then with respect to the affidavit that counsel is referring to, that was put in opposition. In reply. If they knew all of this before, and this supposed peripheral project, why wasn't those affidavits put in with the invoice?
So, counsel, as to an ongoing project, do we have invoices? Do we have construction plans, permits, affidavits, and so on as to an ongoing project, renovation, or anything else there?
No, it would be our contention that this is all a question of fact. The invoice that you see is dated almost 2 months before the accident, and it's only for the gate itself. It doesn't say anything about lighting. It doesn't say anything else about what, if anything, was needed. Then the affidavit says, oh, by the way, after the plaintiff fell, it was canceled. So the affidavit in reply is almost similar to the affidavit in opposition. When was this talked about? When did they start talking? Was any setup done, any pre? Was the plaintiff asked to do any pre-construction? So the issue, the lower court got it right. This is all issues of credibility, documentary evidence that it could be or not be admissible to a trial, and therefore, since that time, discovery has been ongoing. So at the time of this motion, the lower court got it right. It was, first of all, premature. The affidavit presented in opposition was, ironically, 3 days or 4 days after their recorded statement. So the gentleman at issue definitely raises issues of credibility, issues of fact that should be decided either by a jury or a possible motion to re-argue and renew later on after all discovery is completed. Thank you.
I do have a question, and my question is, you know, let's assume that plaintiff made a prima facie case. Let's assume that. You know, why aren't there issues of fact, particularly right before the red light went off? You used the word, I believe, clever. And to me, if somebody's being clever, you know, that, you know, it denotes that maybe there's some truthfulness that's at play. So I'm just wondering, why aren't there issues of fact, assuming, okay, yes, prima facie, but then, you know, we have, you know, the other statement, and it's a question as to whether or not this was part of an overall, you know, renovation project.
So I'm going to give you my take on that, Judge Kennedy, and my take is really very simple, probably a little too simple. I don't think lawyers want to get clients in trouble, and I think they take perjury a lot more seriously than other people do. And they're not going to say things that are going to get their client into trouble. So when you see careful wording, it means something, right? It's the old Sherlock Holmes story, right? There's this terrible murder, there's this gigantic dog, and nobody hears the dog bark, and Holmes deduces from that, from the negative evidence, that the assailant was known to the person, right? Same thing here. It would have been so simple for this person, who's his boss, to say, look, we didn't have a job. There was no construction going on. There was no construction supposed to be going on. This was simply reinstalling a banner. He didn't say it. I don't know why he didn't say it, but I'm assuming the reason he didn't say it is because it isn't true. And the fact of the matter is, to say this is premature, they have an affidavit from his boss. His boss is the one who knows what he did. So it's not premature under your decisional law. I also believe I misspoke, Your Honor. There is one other proof that I'd like you to take a look at. It's the plaintiff's affidavit, 420, and if you take a look from 423, to 434, he circles all of the additional work that was done after his accident. He actually circles it to show you it was done. So again, we think this is reversible on just basic summary judgment principles, and I thank you for listening to me.
People versus Ruiz.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Jordan Ruiz. May it please the Court. The verdict convicting Mr. Ruiz of burglary was against the weight of the evidence. While the evidence showed that a person identified as Mr. Ruiz took a cell phone from a desk in an apartment building maintenance office, it does not show that the person entered the building unlawfully, and it does not show that he entered with the intent to commit a crime.
Sure he did. There was information on the record. The office door entrance clearly had sign there that said office hours, Monday through Friday, say 8 to 5. This was Sunday night at 8:30. And on this record, Mr. Hill, the security person, saw the defendant going into the office. The video shows him looking around furtively, and within 1 minute of being in that office, he swiped that cell phone. So it's reasonable for the jury to have heard all that and said, yes, he was convicted for burglary.
Well, it's not reasonable for the jury to have concluded that he entered for the purpose of a larceny. The sign, first of all, the sign did say the hours, and it was outside the hours.
Counsel, wasn't this a dark office? Were the lights on even?
It's unclear if the light's on from the video itself. I don't see anyone turning the lights on when Mr. Ruiz enters, and I don't see, and Mr. Ruiz is clearly
So
visible.
Mr. Ruiz is fumbling in an office that has a sign outside that says closed, and then when he's asked, how come you're here? He says, I'm looking for a job on Sunday at 8:30 p.m. at night. Don't we have credibility issues that can reasonably be determined by a jury in the people's favor?
Well, for the reasons I've expressed and in my brief, I don't believe so, but I see my time is limited, so I'd like to turn to the sentence issue, if I can. This was, as burglaries go, the least serious dwelling burglary there is. It was in a maintenance office of in the first floor of an apartment building where all the apartments were on higher floors. The minimum sentence of 5 years, which is a very substantial sentence, would have been more than adequate punishment. Adding 2 years onto the fact for stealing a cell phone in a maintenance office is just unreasonable. I've never seen it explained why a 5-year sentence would serve the interests of justice more than a 7-year sentence.
Didn't he have 20 prior convictions, including one for third-degree assault? Didn't he commit a burglary just a mere 4 days after this crime?
Well, he did have prior convictions. They were reflected in the minimum sentence, which enhanced it from a 3.5-year minimum to a 5-year minimum. He was accused of a burglary committed after this one. He wasn't convicted of it at the time that the court imposed sentence. And I'd add, he did ultimately plead guilty to that crime, but he got a 5-year sentence on that. And that was the appropriate sentence, taking into account this conviction and the prior conviction. Again, 5 years is an appropriate punishment for this offense.
And here, the people requested 10 years, but the court certainly imposed 7 years, not the 10 that the people wanted.
Yes, Your Honor, if I may just...
Go ahead, Nancy.
10 years is a ridiculous sentence for a cell phone theft. I pointed out, cited to Mr. Bragg's day one sentencing memo that said these weren't even going to be prosecuted as dwelling burglaries where the office is sufficiently dislocated from the apartments themselves. And this would have been, again, they're not bound by that statement, which was after this sentencing took place. I get that. But that explains that it's just unreasonable to treat a cell phone theft from a maintenance office the same as you would treat a theft from someone's apartment.
Thank you.
Thank you.
You have time for rebuttal.
May it please the court, Alex King for the people. Defendant's belated challenge to the sufficiency of the evidence is unpreserved. At any rate, his guilt of second-degree burglary was proven beyond a reasonable doubt. There was ample evidence of his criminal intent, the most probative of which was that he immediately committed a larceny upon his entry into the office. His knowing and unlawful entry was proven by evidence that there was no lawful way for him to have entered the building. And as a general matter, defendant's explanation for his presence in a deserted part of an apartment building late on a Sunday night was at war with common sense.
Counsel, your adversary seeks to compartmentalize the location of the maintenance office relative to the residential building. Would you address that briefly, please?
There is no suggestion in the record that there were any locked doors between the maintenance office and the apartments themselves. Had defendant not been stopped by this alert security guard who was watching the surveillance video, it would not have been difficult for him to continue on to the apartments themselves, much as he did in Queens 4 days later when he walked through a building trying the doorknobs of different apartments and eventually entered one in which a woman was nursing.
So your adversary goes on to say, yeah, but this was only a cell phone. That's all that what this was. So how come 7 years isn't excessive?
It has long been the case in this state and everywhere else in this country that a sentence must fit the offender and not the offense. Had this been defendant's first offense, the minimum sentence may well have been appropriate. If it had been a second offense, third offense, fourth offense, fifth offense, and so on, but as a matter of fact, I believe it was his 22nd offense.
Counsel, can you address the arguments raised regarding the day one memo?
So the day one memo, of course, is irrelevant to this case for a variety of reasons. One, it was issued after defendant committed his crime and was convicted. Also, the district attorney has made very clear that it does not create rights in favor of any person. But setting all of that aside, and assuming that it does apply, and perhaps there's even law in this case, he is wrong about the day one memo applying to the fact situation here. He writes in his brief that it applies in a case in which the apartments are not easily accessible from.
So in other words, we treat burglars in a locked commercial establishment different than we would treat a burglar of a residential apartment based on the day one memo.
That's correct, Your Honor. What I'm trying to say is the day one memo, assuming that it applies here, would not apply on these facts itself.
Because the maintenance office is really linked to the residential building. The maintenance office services the residential building at Seward Park Housing. So they're inextricably linked. We're not talking about a separate Rite Aid on a corner, right?
Yes, Your Honor is exactly correct. If there are no further questions, we ask that you affirm.
Thank you.
I'd like to return to that question. The day one memo does not support the argument that was just made. Paragraph 6, Section D says commercial burglaries, and I'm quoting, an act involving threat of property from a commercial establishment that could be charged under Penal Law 140-25-2 because such establishment is technically part of a larger structure that contains dwellings shall only be charged as a third-degree burglary. So the day one memo contemplates exactly this situation, that if the maintenance...
But this is not a commercial establishment. This is the resident. The maintenance office is part of the cooperative's infrastructure. It's not a separate, discrete commercial space. It's the maintenance office. It's where the tenants in the building call for the super to come fix a leaking toilet.
I understand Your Honor's point. It is separate from the dwelling portion of the building.
Well, have you ever heard of the super's apartment being part of the other apartments in a building? The super's apartment is separate as well.
And our argument isn't that it applies and could only be charged as a third-degree burglary. Our argument is that it's different than going into an apartment. Going into a maintenance office that's on the first floor is different than going into the dwellings, which are on the 2nd through the 25th floor. That's a consideration that the court should take into account when it's addressing the appropriate sentence. And I still haven't heard an explanation for why a 5-year sentence better performs the interests of justice, better serves the interests of justice than a 7-year sentence. The 7 years is just 2 years of gratuitous punishment. 5 years is a long time for someone to serve in prison. Adding two years to that, what does that serve? I've never heard it articulated what those 2 additional years serves.
Thank you.
Your Honor.
Orano versus 5541.
Good afternoon. May it please the court. My name is Henry Liao. I represent the appellant Ruiz Contracting Group LLC, a general contractor appealing that portion of an order denying its motion for contractual indemnification against subcontractor
Counselor,
H&L.
I'm not hearing you clearly.
Sure.
Could you speak up?
I apologize.
Thank you.
I represent Reading Contracting Group, the general contractor appealing the denial of its motion for contractual indemnification against subcontractor H&L Ironworks Corporation. The court below erred in holding that tribal issues of fact exist as to whether the indemnity provision of their agreement, their master subcontract agreement, was triggered on the basis that H&L demonstrated that its subcontractors were not performing work on the roof at the time of plaintiff's accident.
How do we deal with the fact that the contract in this case is somewhat inconsistent in terms of the provisions? It says two different things. At one time, it says that an act or omission is required to find indemnification, but then there's a later inconsistent provision which would seem to be broader and not require an act or omission. So how do we as the court deal with that inconsistency? in the contract.
I believe if you read the subject indemnity provision, it specifies that.
What?
If you read the subject indemnity provision, there's two provisions, but they both say either an alleged act or an actual act or an alleged act or.
But there's one section that pretty clearly requires an act or omission. And if we give effect to the later inconsistent provision, we're nullifying that provision that requires an act or omission.
Well, the act or omission only applies if it's the rising. Well, let me phrase it this way: the indemnity provision is triggered if the alleged act or omission arises out of the subcontracted work. So here, the subcontracted work is the placement of bricks on the elevator doorway on the roof of the building.
Right, but there's certainly an argument to be made here that this accident did not arise out of an act or omission of the subcontractor's work, that the brick just fell on him while he was working, that wouldn't constitute it arising out of an act or omission on his part, as opposed to a more broad clause, which seems to be later in the agreement, arising from the work. They're two different provisions.
Well, even if that's the case, I believe the Supreme Court also erred in holding that there's an issue of fact as to whether or not its negligence was the
But what if the controlling provision is the narrow one, act or omission? What fact is there? Isn't it undisputed that it didn't arise from the work he was doing, that it just fell on him?
I believe that's incorrect, Your Honor. I believe it's undisputed that the work he was performing at the time was laying decorative brickwork around the elevator bulkhead. Those bricks were only in the possession of both the plaintiff's employer, Reedy, which is my client, and H&L's owner all testified that all of those bricks were only used by Touchstone, which is the plaintiff's employer.
Right, but was it, the court below didn't grant summary judgment, it denied summary judgment, so it didn't say as a matter of law or anything, but wasn't there some evidence presented there's a possibility that it was not the company that used the cinder blocks that were using them in this instance, that another entity was using them to hold down the top, by the elevator on the top? And if that was true, then it wouldn't have arisen out of an act or omission.
Well, it arises if it's relating to the work that plaintiff was performing. If the cause of the accident was the brick that plaintiff says he turned around, he looked at it, and it was the type of brick that his employer, Touchstone, was the only one using at the site, then I would argue that that testimony pretty definitively establishes that it
Right, but isn't there also potential testimony that someone else, another company, was using the brick to hold down the top at the top of the elevator shaft?
The tarp that was being held down.
Brickstone?
The tarp that was being held down was covering an opening in the elevator bulkhead. That opening is the opening that plaintiff was performing brickwork around. So I would say that if, assuming arguendo, that brick was placed by another subcontractor, the allegation is that it was placed by the elevator subcontractor, LCD Elevators. Even if that's the case, it's still relating to Touchstone's work. It was retained to put those bricks around the elevator bulkhead. So I can't see how the court came to the conclusion that it didn't relate to the performance of work under the subcontract. So I would respectfully submit.
What's the act or omission?
The
If
act.
we assume the relevant provision is an act or omission, what's the act or omission?
The act or omission is failing to properly secure the brick, which only all of the testimonies that Touchstone was the only trade using those bricks. If that's the case, I can't see how the court could conclude that it didn't.
But there was evidence in the record that Touchstone had finished its brickwork, and that essentially the elevator company, while they were doing LCD, then took one of these, what do they call, CMUs?
Concrete masonry unit,
Right.
which is the same as, yeah.
Which is the same brick that we're talking about, and used it to weigh down. There was information in the record that they usually would use some kind of iron bar, but instead they took advantage of that extra brick and did that.
I don't believe Touchstone's work was complete. Plaintiff is an employee of Touchstone.
I understand that. But my understanding is in the record that that work was complete in terms of the plaintiff part of the project, but okay.
Okay.
Thank you.
Thank you.
Good afternoon. May it please the court. Patrick Lawless for the respondent, H&L Ironworks. The Supreme Court correctly.
What do we do with this inconsistency?
Well,
It does appear that there's inconsistent provisions in this agreement. How do we handle that inconsistency?
Well, I think I don't think that indemnification can be granted under these circumstances when you have these two competing provisions, because you have the basic tenets of contract law. Number one, that a provision shouldn't be put in the contract where it could be read as being completely irrelevant. And number two is with respect to specifically indemnification, that indemnification, when there's no obligation otherwise to indemnify a party, the language has to be clear and demonstrate the clear intent. And when you have these two competing provisions, it directly conflicts with that. So I don't think that you can grant indemnification based upon this agreement, because you have as you stated earlier, Your Honor, you have the one provision that requires an act or omission, then you have a broader statement that precedes that. So
what happened is Reedy was seeking summary judgment for indemnification. That means they feel the record is so clear that we should be entitled to cover. Bear with me for a second. And now you're saying, and the court basically found an issue of fact because of the inconsistent provisions here. Each side is relying on a different part of the contract. So just humor me. How would a jury trial resolve that issue?
I don't know if a jury can resolve that issue based on, you would have to, I guess there would have to be parole evidence to determine the actual intent of the provision, which isn't part of this summary judgment motion. So, that's the other part of contract law. When you have two inconsistent provisions, then you would need parole evidence to determine what was the intent of the parties, which wasn't part of this record. And as just briefly as to the other point, there is absolutely no evidence, or there's at the very least conflicting evidence, that another contractor had placed the concrete on the tarp and was the cause of the accident, not H&L. Thank you.
Thank you both. Rhodes Associates versus IS Company.
Good afternoon, Your Honors. May it please the Court. Y. David Scharf, on behalf of the appellant, IS Company. The headhunter admits that he didn't do anything after 6 weeks. So what we need to do is look at what, if anything, he did to fulfill his obligations under the contract to substantially perform to be entitled to this judgment for over $180,000.
So, counsel, I'm going to start you off perhaps at a different point.
Sure.
The retainer said that it was unrefundable, right? That payment was unrefundable?
That's correct.
You had to cancel within 30 days of the first?
On one of the contracts, within 30 days if you weren't happy. Correct.
Yes. And here, Mr. Schrager said that he retained the plaintiff, but he didn't recall reading the agreement, and he didn't understand that he would have to make payments. How does that factor into your argument?
It doesn't, and I'll explain why. Because as the move-in for summary judgment, the headhunting firm needed to demonstrate performance or substantial performance of his contract. And it needed to demonstrate that there were no triable issues of fact.
Counsel, I'm going to interrupt because the contract, the only obligation which triggers the requirement for payment under the contract is to identify and present candidates. The evidence appears to show that plaintiff made the prima facie that plaintiff did in fact identify and present candidates within the relevant time frame, and that it was defendant who failed to respond, failed to give feedback, failed to participate in the process. All that's in the record during the relevant time frame. So why doesn't that record establish that plaintiff did its performance under the contract and that it was defendant who was responsible for the process not moving forward? And they're very specific emails in the record which reflect plaintiff said, we've sent you someone, what's going on? Why aren't you responding? And defendants, I'll get back to you, I'll get back to you, I'll get back to you. Not, why are you sending me these horrible candidates and this is outrageous and I'm not paying you. There's nothing like that in the record. It's, I'll get back to you, I'll get back to you. So why isn't that enough to grant summary judgment?
There are two reasons. Number one, the contract had a predicate that for each of the positions, they were going to identify and provide candidates. The fact
That's it. That's the only predicate.
But that means that if they are providing an employee for asset management, if they're employing a senior real estate person, that those people need to be qualified.
So did the defendant ever get back to the plaintiff and say, hey, these are not qualified candidates. What's up here? What's going on? You're not sending me appropriate candidates.
And that's my second point that I wanted to make. Yes, if you look at the emails, Mr. Schrager is either not responsive or he seems to be putting off Mr. Sitman. But what Mr. Sitman and his staff admitted is that they didn't perform. They admitted that...
The whole issue here really is born of an afterthought when Mr. Schrager addressed all the candidates presented, and it so happened that the first two candidates that were presented were former employees who allegedly were fired. So after the fact, in response to the motion here, Mr. Schrager is saying, well, gee, they first sent these two candidates, and therefore I was dismissive of the whole process.
Well, if you...
To create an issue of fact. When as was pointed out by my colleague here on this record, he didn't come right up front and say, what are you sending me out of the box?
But he didn't have to, okay? And because what the headhunter needed to do was present qualified candidates, and they had the burden to demonstrate that they actually did that in order to be granted.
Counsel, the only way that that would be so is if these persons were interviewed or evaluated or if some feedback was provided. That didn't happen here. Instead, Mr. Schrager said, hey, I was just at Disney World with my family, or what are you bothering me for? I have other, do you think you're the only, what did he say? Something awful about, are you the only person in my universe, or do you think I don't have time to, I mean, there was no feedback of any sort, was there? There were 4 candidates submitted for one position, including the two allegedly ineligible people, and then there were 23 people submitted for the other position, and yet nada, zippo from Mr. Schrager, who didn't believe that he had to pay any money anyway.
It is not correct that they submitted 23 other people. For that list, the admissions were that, number one, no work had been done. So when Mr. Sitman wrote, I've been working on the search actively, he convinced Mr. Schrager that he was lying to Mr. Schrager because his own employee who was responsible for that search said they had done nothing. And the best that Mr. Sitman was able to acknowledge at his deposition was that of all the listing of those 23 people, maybe they interviewed one person, but he hadn't done it. The person that was responsible for the search said that nothing had been done, and the court awarded $62,000 for that.
Also, how do you respond to the position that plaintiff makes that that these 4 candidates were benchmark candidates, and in order for them to continue with the process, that they needed input from the defendant, and that was not forthcoming?
Number two, so two answers, and I recognize my time is up. So number one, Mr. Sitman acknowledged that he had gotten all of the information that he needed from the meeting that occurred with Mr. Schrager. Number two, he acknowledged that the second step that needed to happen afterwards was he was going to create a position, a statement of what the qualifications of that candidate were going to be before they went forward.
It seems to me that what you're arguing, it seems to me that what you're saying is that because they didn't send what you deemed to be qualified candidates, that he didn't have to respond.
No, what I'm saying is we get to go to a trial where a trier of fact can make a decision, and a jury can decide whether or not Mr. Sitman and Rose is entitled. They're certainly not entitled to summary judgment when the burden was on them to establish that there were no tribal issue fact, that they did all the things that they committed and obligated to do.
Thank you.
May it please the court, Michael Fishman on behalf of Respondent Rhodes. We're here 5 years, almost to the day, that Rhodes had to bring a lawsuit in order to recover the payments due under the two very short agreements by which it wasn't required or was obligated to identify and present candidates for certain positions, including one that was going to be, as Mr. Schrager himself points out, a needle in a haystack. The guy who was going to be working with Mr. Schrager may be becoming Mr. Schrager one day and running the enterprise. We've been doing this for 5 years. We've been, and when we speak about clever arguments, we began this process with, and you'll see on the record, first that there was, that Mr. Schrager was trying to cancel the contract. But when Mr. Schrager testified, he said, no, that never happened. They said that we only presented candidates that Mr. Schrager already knew, or that were known or that worked for the company. Well, that turned out not to be true as well, and that went off by the wayside. What is clear and what is unmistakable is that these contracts provided for a non-refundable payment on day one. And Rhodes, Mr. Lippman, continued to work even as he pressed for payment, as he begged Mr. Schrager to meet with candidates, including a candidate Mr. Schrager wanted to meet, Mr. Selman. Mr. Lippman stopped working, not because he was not being paid, but also because he had to deal with his own reputation in the industry. He was telling people that I have the job. You're going to work for Mr. Schrager.
Your adversary says that it's not true that 4 plus 23 candidates were presented. That number is not true, and that those persons first had to be preliminarily interviewed by your client.
Yes, first there were two positions. There was a position that Mr. Schrager's, associate, and then there was another position. In neither case did anybody bring forward or meet with Mr. Lippman after their initial meeting to help him identify from the list of 23 and the 4 who he could present and have further interviews with. They vetted 23 candidates and 4 candidates, but you cannot find a way to get to Mr. Schrager if Mr. Schrager or his associates will not meet. It's akin to hiring someone to paint the inside of my house, signing a non-refundable contract, and when they arrive at the door, not letting them in, and later saying, I think this is what the argument is, that you don't get summary judgment on the non-refundable contract because maybe the painters were no good. How do I know if they went to spill paint on my floor, or if the paint was of good quality, or that the brushes were good? And you need a trial, and some triers of fact can somehow determine whether or not the work that was being done was being done. The contract said Mr. Schrager could have done anything. Mr. Schrager could have chosen to have a daily meeting with Mr. Lippman. He could have asked for weekly reports. There was nothing in this contract that had a minimum or a maximum. It was Mr. Schrager who, as you point out, says that I went to Disney World. No disrespect intended. He also, as you pointed out, what he said was, if you would just calm down and be patient, not be so obsessive, and wait for me to contact you, things would be much better. I'm obviously busy and distracted, and my world does not revolve around you. That's what you're remembering, and that is exactly what was happening. Mr. Lippman was trying to get Mr. Schrager to do what Mr. Schrager came to him to do. Find me a candidate to work with me, to help me become, when I retire. Maybe he had a change of heart, maybe he did become too busy, but the contract payment was due on the day that they signed that agreement.
Thank you.
And unless anyone has any further questions, thank you.
Thank you very much.
We don't grant summary judgment because we don't like the way Mr. Schrager communicated to Mr. Lippman.
No, but what is the meaning of unrefundable, counsel?
So I want to pick up on his analogy to answer your question, if I may.
You're going to have to connect them.
I will. The painter who shows up at the house with paint and paintbrushes and doesn't get in, that's prevention of performance. But when you hire somebody to paint and you send somebody to do demolition, so you're not sending and you're not fulfilling the basis of your contract. The contract can be, say, non-refundable.
How do you know that they're sent to do demolition if you don't talk to them?
Because Mr. Lippman himself admitted, and this is what I'd like to answer your question. Mr. Lippman writes, and this is the great email that Mr. Lippman writes, we're actively interviewing candidates for the public asset management position. We expect to begin interviews at some point. But what does Julie Marcus tell us was actually going on? No, nothing has been done regarding this asset management search as mentioned earlier.
Thank you, and we are familiar with the record. Thank you very much. Beretto versus Board of Managers.
Good afternoon. May it please the court. Michael Cassell for the plaintiff respondent, Eduardo Beretto. In this matter, the label of 240 case, my client who was doing exterior window washing fell while doing the window washing because apparently one of the ropes that he was using was severed on the balcony, causing him to fall. I cited in my brief the Loiza case, which I will note was decided after the Supreme Court decision, which was a case that I argued before, I think, two of your honors here today. Basically the same employer, Mark Prince, same circumstance, the plaintiff is window washing, and the rope breaks and the plaintiff falls. In this case, like as in Loiza, the lower court found a question of fact as to whether my client was the sole proximate cause. As we
Did that case also involve a rope guard?
I'm sorry?
Did that case have the same issue of whether or not a rope guard should have been used?
The case of the lower court in Loiza found one of the questions of fact was whether the rope grab was used too low. Correct.
The rope guard I asked you about.
The rope guard?
The rope guard.
Oh, no, there was no rope guard on that issue, but in Loiza, my client, for purposes of summary judgment, we would acknowledge that he put the ropes too low. In other words, the rope never even reached the ground. This is a situation where defendants argue that my client should have put a rope guard in place.
The reason I'm asking about the rope guard is there seems to be two issues. The court below denied one, but your opposing counsel is still arguing very strongly that the failure to use a rope guard was the sole cause of an accident and that the rope never would have been severed if a rope guard had been used by your client and your client had a rope guard available to them and chose not to use it for no good reason. So why wouldn't that at a minimum raise an issue of fact?
It doesn't.
As to whether summary judgment should be granted to the plaintiff on the
Sure, I submit it doesn't come close to raising an issue of fact because if the argument is that the rope guard should have been on the repelling line, defendants cannot dispute that the safety line failed, which was the exact issue in Loiza. My client has two ropes. If they say he should have used on the repelling line, the safety line failed exactly as in Loiza. If the safety line failed to prevent my client from falling, he's entitled to summary judgment.
Isn't there also an issue? I'm sorry, go ahead. Go ahead.
I'm sorry, my understanding is that one of the issues is with the rope grab, and that the claim is, as in Louisa, the rope grab should have been above the head, and here it was allegedly by his hip. Am I correct?
That is, yes, correct.
So their position is, if he didn't position the rope grab appropriately, then that could be, among other issues, a contributing factor or a sole proximate cause here, or he was a recalcitrant worker for failing to appropriately use the rope grab in the course of his work. That's one issue. The other issue is with respect to the rope guard, they asked for it, your client asked for it, but then they assessed in terms of the smoothness of the balconies and the rails that it was unnecessary to use the guard, where their position is that they intentionally chose not to use the guard, and therefore, by failing to use the guard, that was the sole proximate cause of the accident. It's an issue here, as opposed to your contention that it's a slam dunk.
Well, it's no issue, Your Honor, because to be very clear, it's sole proximate cause, meaning if 99% of the cause of the accident is my client's failure, we win summary judgment. So we have an issue here where there's indisputable evidence that he was never told to use the rope guard on the balcony. So he can't be a recalcitrant worker because in Lamachi, as this court has found, my client has to be instructed specifically, you need to use a rope guard there. There's no evidence.
Counsel, there's two, are we talking about two devices at the same time? One that goes on the rope and one that would go on the balcony?
No, well, let me explain. There's a rope.
There's a difference between a rope grab, which is on the rope, which is attached to the harness via a lanyard. The rope, am I right?
There's two ropes. The lower court found a
The
question.
main line, and there's a harn, and
And a
there's a
safety-
safety line.
Right.
And the rope grab is attached to the safety line. yes?
Correct.
That grab has to be attached above your head in order to work. And the purpose of the grab is to lessen the amount of a fall should you fall. Am I right?
There's no evidence that the placement of the rope grab would lead to the safety.
No, I'm asking you a mechanical question.
Makes no difference at all where it is, but there was some.
So if it's on your waist, it achieves the same function?
Yes, it has. There's no evidence to dispute it would achieve the same function, albeit I guess the worker could fall another foot and a half.
Did the plaintiff submit the report of an expert to explain that?
No, but there was no evidence whatsoever. His own coworker said he's never seen my client use the rope grab other than above his head, and my client testified he's always used a rope grab above.
Okay, so let's hear, I'm sorry, do you have more questions?
I have a question, if I may, and it's be very brief. So, what do we do with the evidence in the record that your client, I believe, requested a rope guard, but for whatever reason later decided not to use it? What do we do with that?
Sure, he had a rope guard on the rope. He saw what looked like a dangerous situation, which was below him, but he did not. So when he fell, there was still a rope, what's called a rope guard, which, by the way, there's no evidence that the rope guard would have even prevented the rope from shredding. But putting that aside, there was a rope guard. He didn't see the balcony railing as being a dangerous situation. In fact, defendant's own experts say there's nothing wrong with the balcony railing. Plaintiff's coworker said that nobody could realize that below this curved railing was another rail. Nobody knew. And most importantly, to hold my client liable as a recalcitrant worker, there must be some evidence that he was told you need to use the rope guard in this location. There's
you
no
have
evidence.
time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court, Lauren Turkel. I represent the board defendants. Counsel is conflating recalcitrant worker and sole proximate cause. What we have here.
We don't use recalcitrant worker anymore, but everyone keeps using it. I thought that's out. Now it's just sole proximate cause and not so. But anyway, go ahead.
What we deal with here, which is very different from Louisa and all of the other cases cited by my adversary, is that it is undisputed in this record, including by the plaintiff himself, that he was provided with all necessary equipment. That equipment did not fail. The failure in this case was of the plaintiff, with 20 years experience, multiple OSHA certifications, who owned his own business of window washing, failing to identify an area which he admits he was solely responsible for identifying, and failing to guard it with a piece of equipment that was tethered to his body at the time that he fell. When we deal with that isolated issue, you never even get to the other issues of the safety line, of the rope grab. It becomes irrelevant because the sole proximate cause of why this accident occurred was the failure to use an adequate and appropriate safety device tethered to his body at the time of the accident. It distinguishes this case from Louisa and all of the other cases cited by the plaintiff where there's an inadequacy of devices, a failure of devices.
Counsel, your adversary says that the positioning of the rope grab was irrelevant.
Well, I mean, that's simply not supported by the record whatsoever. I mean, Mr. Cardenas is quite clear, as is Mr. Prince, that the positioning of the rope grab is what prevents you from falling. When it's above your head and you begin to fall, it catches you immediately. In this case, because he had it too low, it caused him to fall to the balcony below. What they say is it would have initiated, it just did not by the time he hit the setback below. Very briefly, as I see my lights on.
What is your response to your friend's comment that in cases, an element of sole proximate cause is being given express instructions and ignoring them, which wasn't the case here?
I believe he's confusing that with recalcitrant worker. Sole proximate cause is that he was provided with adequate safety devices and failed to use them or misused them. In this case, he failed to use it entirely with regard to the rope guard and misused it with regard to the rope grab. So you've got it twice, though you only need it once.
Counsel, a clarification then. We are talking about two devices?
Absolutely.
The rope grab and the rope guard, which the rope guard would be the protector that goes perhaps over the horizontal railing or
balcony.
underneath it. Yeah.
Yes, it protects the edge from being cut. And Mr. Cardenas actually said that you only needed one at the top level, and if you had done that, the angle would have prevented you from needing one anyplace else. I would just finally very briefly note that should the court disagree in some way with the fact that plaintiff was the sole proximate cause and dismissed the 240, as we've argued in our brief, has my adversary, we believe that Chelsea was a proper labor law defendant and should not have been dismissed. We rest on our papers. Thank you.
Thank you.
Good afternoon. May it please the court. Edward Tobin, Gallo Vitucci, for defendant respondents Chelsea. The record in this action makes clear that our clients had no authority to exercise supervision or control at the work site. Unless the court has any questions, we'll rest on the brief.
White case. The White case, which says that if you have that authority, which they did as a subcontractor assigned to do the work, that's enough to keep you in as a statutory agent, even if someone else is given the work by the subcontractor.
Well,
Why isn't White right on point?
There is no contract between us and Prince in this action, and the record makes clear.
Isn't there a contract between you and the building that you're going to do the work?
Yeah, but
So why doesn't that contract make you the statutory agent for this particular work?
Well, as set forth in our brief, and the record makes clear, we were merely a middleman, and
Right, but what White says, that doesn't get you off the hook. If you are the contractor for the work, and then you give the work to someone else to do, that doesn't relieve you of liability.
I respectfully disagree, and I refer back to our brief and the line of cases that we
Thank
submit.
you very much.
Thank you.
I'll just go back to, in response to my counsel's argument, I once again would just note in Loiza, there was an argument that my client, Mr. Loiza, failed to basically create a knot at the end of the rope, which would have been a safety measure. And this court said, despite plaintiff having failed to perform this safety measure, which was tying a knot, which I submit is analogous to putting a rope guard, this omission was at most comparative negligence, which is not a defense.
Tying a knot is analogous, is similar to a rope guard or a rope grab?
Because in Loiza, my client, what happened was the rope was 20 feet above the ground. So as he's rappelling down, he falls because there's no knot at the bottom of the rope.
The argument here is that the failure to use the rope guard was the sole proximate cause. If the jury accepts that argument, then it's no longer in the arena of comparative negligence.
Well, if it's sole proximate cause, but in this situation, Your Honor.
Aren't they arguing that both, her argument seems to be that both as to the rope guard and the positioning of the rope, that both of those independently were the sole proximate cause of why this accident happened.
I respond briefly. We know the safety line failed, which automatically means in a cause of the action.
Couldn't it have failed because of the absence of the rope guard?
No, the safety line they're claiming failed because he didn't put the positioning of the rope grab, they're claiming, which is a difference of 2 feet. My client fell 12 feet. Now, and lastly, Your Honors, what they're saying here basically is my client was...
Counsel, aren't they also arguing that there was no rope, there was no protector, there was no rope guard, and therefore it's sliced?
They're saying there was no rope guard. They're saying my client was tasked with creating his own safety device, but putting the rope guard. Every case says the onus cannot be placed upon the plaintiff to create his or her own safety device. It turns the entire label on its head.
He had the rope guard there. That's undisputed.
The devices were provided.
The rope guard was there.
He had and lastly...
He didn't use it.
And lastly, very quick, the lower
So your
court...
time's up. Thank you very much.
Very, very briefly. Just the distinction between Loiza and a rope that was missing a knot at the bottom for anybody to see, including Prince when he's setting up the cones on the sidewalk below, other coworkers, people walking by on the street that could go, hey, your line's too short, it didn't hit the ground, it's missing a knot. We're talking about 11 stories up in the air. There is only one person 11 stories up in the air with the ability to identify where that rope guard needs to go. And it's the plaintiff who had the experience, the training, and the equipment tethered to his body. He failed to identify the point, failed to use the equipment that was already provided to him for that exact purpose, and that was the sole proximate cause of this accident. Thank you.
Thank you. People versus Clark?
Good afternoon, Your Honors. The Legal Aid Society by Megan Teschler on behalf of Mr. Tony Clark. In this tragic case, which began with the brutal beating of Mr. Clark, a dedicated father of two, Mr. Clark's excessive sentence should be reduced in the interest of justice. Mr. Clark is a family man. Before this incident, he worked...
So before we get there, what do you say about the waiver?
Your Honor, I would say the waiver was invalid because the court's colloquy was convoluted and confusing. The first issue I would like to point out is that after the court lists what an appeal is and what appellate rights are, it's page 16 of the plea proceeding. He says the judge says you will be able to raise any issues related to your conviction and conclusions following a trial. This is very confusing to someone. Does the waiver apply to his plea as previously stated? But now he's saying, well, this is only related to your convictions and conclusions following a trial. This is a convoluted explanation of the waiver at best.
In addition to that oral waiver, there was a written waiver, correct?
Your Honor, yes, there was a written waiver here, but
the court did verify with your client that he went over the waiver with his attorney and that he fully understood it, and the client said yes.
That is also correct, Your Honor, but I would like to point out that the written waiver was actually executed before the court's colloquy occurred, so it could not address any confusion caused by the court's colloquy in the first place. Secondly, the waiver, as courts have held, a written waiver cannot cure a particularly defective oral colloquy. And the third thing I'd like to point out about the written
So you
waiver...
agree that if we find the waiver valid, that your argument with regards to reduction is foreclosed?
I'm sorry, what, Your Honor?
Do you agree that if we find the waiver valid, that your argument for reduction is foreclosed?
Yes.
Counsel, the court did say that there were a limited number of claims that would survive the waiver that included the voluntariness of the plea, the validity and the voluntariness of this waiver, and the legality and jurisdiction of this court, yes?
That's correct, Your Honor, but this is in conjunction with the confusing language regarding convictions and conclusions following a trial.
Did that language clarify the prior language?
No, Your Honor, I don't believe it did. I believe it was further confused. Mr. Clark, a layperson, he's not an attorney here, that what is this waiver actually saying? What am I doing here? What are my appellate rights?
Would it be correct to say that your client has prior experience with the criminal justice system to the extent that he had a prior assault in '97, an attempted assault in 2002, 2 assaults in 2010, and a DWI in 2019?
Your Honor, Mr. Clark's violent felony record is over 2 decades old, and it occurred when he was 21 and 16 years old. And furthermore, there's no record evidence. The people did not present any record evidence that Mr. Clark ever executed a waiver of the right to appeal. Experience with the criminal justice system in and of itself is not evidence that one has experience with the waiver of a right to appeal.
Your client here was sentenced to 14 years and he was convicted of manslaughter. Someone lost their life here. So what's the argument for reduction?
Your Honor, the argument for reduction is that Mr. Clark spent 2 decades living a largely nonviolent life. He worked 2 jobs to support his family. He has 2 young children who are in the throes of adolescence, waiting for him to come home. He will miss out on their very formative years. Mr. Clark is very remorseful of his actions here, and the facts and circumstances of this case are very tragic, and Mr. Clark was a victim in and of himself during this case.
But after he was assaulted by the victim, he went home and came back and shot the victim in the torso. I mean, that gave it a little thought. We're not talking about a spur-of-the-moment decision to defend himself.
After Mr. Clark was brutally beaten so much that he received a concussion and a through-and-through laceration to his jaw and was very confused, he came back to the bodega to look for some teeth. Unfortunately, he and Paul, the other individual, encountered one another once again, but Given Mr. Clark's state after the beating, I don't know that.
Counsel, he was concussed and he shot somebody?
Your Honor, he was in fact concussed and he shot someone, but he did not return to the location to shoot someone. He returned to locate items, his wallet.
Came with a gun. Thank you very much. You have time, rebuttal.
Good afternoon, Your Honors. Andrew Loizides, appearing for the people, and may it please the court. Your Honors, the waiver to the right to appeal here it's valid. He knowingly, voluntarily, and intelligently waived his right to appeal.
Would you acknowledge that it's somewhat confusing?
I don't, well, I mean, even if he had any confusion, and the lower court asked him, do you have any questions? And the judge and the defendant said, no, I don't. And did your attorney explain everything to you? Yes. And he confirmed with counsel that, yes. Did you explain everything to him? Yes. And did you have any questions? No questions. Then he confirmed on the record that he understood everything that was being told to him and that the written waiver explained everything to him as it was supposed to. He understood what was happening. And unless Your Honors have any questions regarding the waiver, I would just point out that his sentence is not excessive in light of the fact that his actions led to the death of somebody by shooting the victim in the torso with a gun. And the fact that all the factors
Also, I think well, I shouldn't think for you, but I guess you wouldn't disagree that on this record, the defendant was the victim of a brutal, unprovoked beating.
I don't disagree with that at all. That
problem is that he left and came back with a gun.
Precisely, Your Honor. Yes, the fact that he left, came back with a gun, saw the initial aggressor, then his victim, and shot him in the torso, killing him. And all the factors that defendant states in their argument, where saying that he's a family man, that he was missing out on his children growing up. Those were all
known to the court.
Exactly. Yes, Your Honor. That was all known to the court. In fact, the court required both the prosecution and defense to explain to the court why was this plea in the interest of justice for him to plead down from murder to manslaughter in the first.
In all fairness, also my understanding is that the prosecution didn't believe that under these facts it could get a murder conviction.
That's correct, Your Honor. Yes, there was a chance, a risk that he might be convicted of murder too. He might not be convicted.
People also wanted 15. They offered, but counsel insisted on 14, and the people agreed.
That's correct, Your Honor. Yes, yes. Unless Your Honor has any further questions, the people respectfully submit on the brief. Thank you. Thank you.
Briefly, Your Honors, with respect to the issues that I outlined about Mr. Clark being a family man and working and this being an aberrative behavior for Mr. Clark, those issues needed to be before the court below in order to be before this court. Logically, that's how this works. I'm asking this court to consider those factors. I do want to point out that the prosecution below described Paul's conduct as very abusive, violent, and says a jury will have great sympathy for Mr. Clark, and Paul did nothing to justify the use of force. He was not confident at all that he could prove a murder to conviction. As with respect to Mr. Clark returning with the gun, he returns to the bodega again to look for items. There's no indication that he knows that Paul will be at the bodega when he returns there. There's no evidence to show that he knows this. So how can he goes and looks for his item?
Counsel, don't these factors get calculated into the reduction from the murder two to the manslaughter one? Because doesn't manslaughter one talk about acting in the throes of extreme emotional disturbance? And isn't that what you've been talking about all this time? Your client was the victim of a really vicious beating, and therefore that was an extreme emotional disturbance.
Your Honors, in part, yes, but I'm also arguing that this behavior, Mr. Clark spent 2 decades not engaged in any type of violent behavior. He was a productive member of society. He was working. He was taking care of his family who supported him for the entire duration of this case.
Did he say he was unemployed when he had the interview?
No, Your Honors, he worked 2 jobs, and he said that he worked a job with a moving company and also another job. This was never disputed, and it was verified by, I forget what agency.
I may have confused it with someone else.
Thank you very much.
Thank you.
Thank you, Your Honors. you. Have a good night. Have a good holiday.
Mike did a good job, right?